Safia. Yes, Lordship. Deeply obliged.
Lordship, yesterday's judgment I have already been hearing, madam. Same business matter. Same business matter, madam.
Judgment you want.
Yeah, yeah.
Okay, I'll take care. Yeah, yesterday the one matter was I kept in CV.
Yes, yes.
But we have passed that order yesterday only.
Order, oh yes, that was
That quashing matter.
Quashing matter, yes.
Okay, that we have already passed.
Oh yes, yeah. Husband wife matter.
Yes.
My lord, FIR is in page number 11, my lord. 10, my lord. FIR is in page number 10.
How many people have accused are there?
My lord, only accused, two accused are here. My lord, here what?
One is Rahul Islam, one is Ariful Islam.
My lord, the
1 second.
actual this
1 second.
I am accused number 2, my lord.
Proceed submitted. You go there.
My lord, I went there, my lord. Actually, what happened, my lord? In this case, actually, what happened? I am accused number 2. I am nowhere related with.
No. Allegations are against both of you. They are still me.
Yes, my lord. The case how it started is that accused number 2, Evan, he used to go to the school.
Now charge sheet is filed. What do you want? You go there and appear.
I went there, my lord. I went there also. They have rejected my case, my lord. I have annexed that also as annexure 2, my lord, page number 7.
Then you don't have any case.
My lord, may kindly call for TCR, my lord.
No. There is no requirement. Heard MS.
My lord, kindly, my lord, may kindly call for TCR.
No, not required in this case. We wherever is required, we call for a.
My lord, actually, my lord, I am nowhere related.
No, both of you were there.
And my lord, one thing, my lord, kindly, my lord, kindly, my lord.
Yes.
My lord, that is in page number 11, my lord, in 7th line, my lord, it has been written that due to the beating of accused person, Shohid Ahmed's dhow also breaks down. My lord, it is not me that I was carrying dhow, my lord. Actually, they were carrying.
But you were there, no?
I will, because my lord, I was there because they have approached me to reach to accused number 1, my lord. They have called me to settle the matter.
No, this is not a case that is.
My lord, they have called me as a tool, my lord.
No.
They have used me as a tool, my lord.
It will
They
be
have
difficult,
used me
madam.
as a tool, my
It will
lord.
be difficult, madam. It will be difficult.
My lord, in this case, my lord,
Heard-
then, my lord, I want to withdraw, my lord.
Please withdraw. I heard MS
SD Chaudhary.
SD Chaudhary, the learned counsel, appearing for the like this, right like this on the prayer of MS SD Chaudhary, the learned counsel, appearing for the accused applicant for withdrawal of the instant ABA application. The instant ABA application is dismissed on withdrawal.
Yes, my lord. Obliged, my lord.
25, where you Please, your lordship. Lordship, scope of a petition call for you. Sit, your lordship. Appeared at page 11, translated copy, your lordship. Lordship, I'm behind the bar since 126 days, your lordship. I'm regularly appearing because, but due to lapse of the communication with the engaged counsel, yes, I remained absent, your lordship. After the NBW issue, and I was apprehended, your lordship.
You apprehended.
Yes.
Now you are behind the bars.
Behind the
Again.
since 126 days, lordship.
Mm.
Already 5 out of 8 witnesses, our 5 witnesses already examined, your lordship.
Worship, revisions was awarded to judicial custody on 6/4/2019. Thereafter, he was released on bail on 27/05/2019. Thereafter, worship on 29/05/2018, offenses has been taken, someone has been issued to the accused persons. And thereafter, worship, on civil officials, he is rightfully read the process of adoption. And only on the basis of the strength of NBW, he was
Arrested.
arrested on 14/4/2006.
Before that, I am regularly
14?
appearing.
14/4/2006.
26.
26. And after it, he is behind the bar. And what is the stage now?
Total 8 listed witnesses. 5 has been examined, Lordship.
5 have been.
Yes.
Your lordship.
So it is on the verge of completion of the trial proceeding.
No, your lordship, already I have behind the person 126 days, your lordship. And I am regularly appearing, your lordship. I have annexed already. Only 5 dates are missing because I am a household person in Gauhati. I don't know dates and communication with the engaged counsel. That's why I'm 11%. I don't know the legal procedure. That's why I'm ready to appear. No dates will missing in, after the your lordship. So kindly allow me.
Okay, heard, Mr.
R. Ali. R. Ali.
R. Ali, the learned counsel appearing for the accused applicant, also heard as Assis Boda, learned APP for the state. Reason application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Sessions case number 87/2021, arising out of Telamala police station case number 41/2019 under section 302 of 302 PC. When FIR was lost. FIR was lost before officer in charge Phenomena police station. This station. On 6/4/2019. Releasing that the accused person had killed the sister-in-law of the informant while she was sleeping by burning putting kerosene and putting kerosene or oil on her. After after the fire, the Telamura PS case number 41/2019 was registered against the accused applicant. Full stop. After investigation, police filed charge sheet number 21/2019 dated 30/4/2019. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicant is a housewife and she has been attending the trial. However, on certain occasions, she could not present before the trial court due to the miscommunication with her lawyer. He submits that due to such non-appearance, NBWA was issued, and thereafter she has been arrested. When was arrested? 14/4/2026, and since then she is behind the bars. He submits that the accused applicant is already behind the bars for how many days?
I think 129 days.
129 days,
14/4.
and she will cooperate with the investigation, and therefore she should be granted bail by this court. Full stop. On the other hand, the learned MSSL fellow, learned counsel, learned APP, appearing for the state, opposes the clear of bail application, saying that the trial in the instant case is proceeding in a reasonable speed, and the same is expected to be completed soon. She further submits that the accused applicant was evading arrest, and due to which NBWA had to be issued, and on the strength of the NBWA only, the accused applicant was arrested. Full stop. TCR in the instant case has been received and the same is perused. It is seen that the accused applicant was issued, and the accused applicant was not regularly attending the trial, and therefore NBWA had to be issued. Full stop. It is also seen that the trial is going on in a reasonable speed, and at this stage, this court is not inclined to grant any bail to the accused applicant. And accordingly at this stage, then you write, accordingly, and therefore the instant bail application is rejected.
26.
May I please allot? We also ask for office to date 19/8/2021 or 19/8/2026. Service report is awaited in respect.
The POCSO matter, huh?
It's a POCSO case. Sir.
Service awaited.
Yes, sir.
For official 19/8/26. It is taken on 17/8/26.
Not 17. Just, so the date-
We will wait for some time.
Yes, yes.
Heard Mr.
As Deka.
S. Deka, the Allied Counsel, appearing for the accused applicant, also heard Mr. K.K. Boshal, and APB for the state. Office note dated 19/8/2026 reveals that service report as regards service of notice upon respondent number 2 is still awaited. Let the matter be listed on. Let the matter be listed on.
Can it be on 27 year also?
10th of September.
27.
Please, your lordship. This is an application under section 483 in connection with the lordship PUPS case number 26 of 2020.
CD has come.
Now, your lordship, out of 4 number of accused persons, 3 numbers of accused person has already been released, your lordship, by this honorable judge. I want to praise.
Chief CD called for, yet we have not received of it.
On 18th, Your Lordship, one of the co-accused.
Okay, that matter.
Yes, Lordship.
That will grant him.
Yes, Lordship.
Yeah, your name is?
SD Roy, Your Lordship. However, Lordship, one.
No, I mean, what is the accused name?
Accused name is Your
Deepu
Lordship.
Das, Lordship.
Deepu Das, Your Lordship.
He was named in the FIR.
Yes, yes. FIR at page number 15. 15, Your Lordship.
Come disobey.
In the earlier order, it was written as CCM Nalbari.
Yes, Lordship.
Have you corrected it?
I am earlier, the accused person's engaged counsel is somebody else, Your Lordship. I am for Mr. Deepu Das, Your Lordship. Here, the Ilaka magistrate is Tihu, JMFC Tihu.
But it was written as CCM
CCM
Nalbari. That's what it was told to the court.
Yes, Lord. I place before the honorable court that it should be before JMFC. Tihu.
Now, I do not know what has happened to this P. Das. Who is this?
Not aware yet.
Okay, heard Mr.
SD Roy. Your Lordship.
SD Roy, the learned counsel, appearing for the accused applicant, also heard Ms. S.H. Bora, the learned APP for the state. There is an application under section 483 of BNSS 2023, praying for granting bail to the accused applicant in connection with Tihu PS case number 26/2026, registered under sections 309/4/115/126/111 of BNS 2023. An FIR was lodged on 25/7/2026 by the complainant, Muhammad Bilal Ali, alleging inter alia that on 15/6/2026 at around 10:30 AM, when the complainant reached at Natkuchi Chowk, at that time, the accused persons, namely Kapil Roy, Deepu Das, Tapan Roy, and other two persons of MD Finance, MD Finance Associate. What is the name of your organization? MD Finance Associate or Associates?
MG Associates Debit Collection.
Or
Agency.
associated, what? What is the name of this?
MD Associates Debit Collection Agency. Your Lordship.
MD Associates Debit, right, MD Associates Debit Collection
Agency.
Agency forcefully, Natkusi, forcefully snatched his motorcycle bearing registration number AS-15U-0753, semicolon, that on 16/7/2026, the complainant deposited an amount of rupees 5,000 on phone pay and rupees 5,000 paid in cash to the accused, namely Kapil Roy, but the accused persons did not return his motorcycle. Semicolon, that when the complainant went to the office of the accused persons to collect his motorcycle, the accused persons had beaten him up and snatched another amount of rupees 30,000. Full stop. On the basis of the FIR, the police registered Tihu PS case number 26/2026 under the aforementioned sections. The learned counsel, appearing for the accused applicant, submits that the main accused persons, namely Kapil Roy, submits that two of the accused persons, namely Kapil Roy and Tapan Roy, had already been granted bail by this court, by this court. Full stop. You're behind the bars for how many days?
Lordship, almost. I
Almost, no, the count.
Yes, sir.
He's
Arrested on 26. So it will be
you should be ready with your
sorry, Your Lordship, 24 days.
24 days no should be when he was arrested.
26, your lordship.
26.
Yes.
26.
He submits that the accused applicant has already spent more than 24 days behind the bars, and therefore the accused applicant should be also granted bail, bail at this stage. He submits that he was arrested on 26/6.
26, 7, Lordship.
7/2026 and has already spent more than 24 days. No? 24 days, taking into account the fictional position and the period of detention already undergone by the accused applicant, and the fact that other two co-accused have already been granted, this court is able to consider the opinion that the accused applicant should be granted bail. Full stop. Accordingly, it is directed that the accused applicant, namely Dipu Das, shall be released on bail on furnishing of a bail bond of rupees 20,000 with a surety of like nature to the satisfaction of the learned JMFC, TU Norbury, subject to the following conditions: that the accused applicant shall cooperate with the investigation and make himself available as and when called for by the investigating officer. And number two, accused applicant shall not tamper or hamper with the investigation in whatsoever manner. Then in terms of the aforesaid direction, the instant bail application is disposed of.
Highly obliged, your lordship. However, your lordship, he is in judicial custody for 26 till date 26 days.
So right 26 days.
Much obliged.
28, same prayer, Lordship. CD call for that we have not received. Lordship.
CD not received.
Not.
Okay. CD not received. CD not received. Get the matter be listed on.
Also, there is interim.
Get the matter be listed.
Insurance agent.
9th of September. 9th September and 9th September. Interim order so fast away shall continue till the next day.
In this case, SK1 can you plus call for on next date 2/9/2026 for appearance of the
Your Lordship,
petitioner.
sir.
The next date is appearance for the petitioners in the trial court on 2/9/2026.
Your Lordship,
And
press-
after granting interim mailer, they are appeared mailer, subsequently charge sheeted mailer.
Yes, madam, is there anything?
Lordship, I'm sorry, Lordship, I could not go through the scanned copy of TCR. Lordship, there's an office note perhaps.
Cognizance already taken. And fix the matter for appearance on the next date is given 2/9/2026.
So you, you go and appear.
Yes, my lord.
Let him
Yes.
go and appear. Heard Mr. A. Mohammed, the London Council appearing for the accused applicant, also heard Ms. S.H. Boral, APE for the state. This is an application under section 482 of BNSS 2023. 23. Praying for granting anticipatory, praying for granting PRS bail to the accused applicants in connection with Tezpur PS case number 148/2026 under sections 191 in bracket 3, smoke stroke 1090/118 bracket 2 stroke 1305 bracket small a BNS. The case arose out of an FIR. Next one. The case arose out of an FIR dated 23/3/2026 lodged by one Rafiqul Islam, alleging that on that day, when they were traveling in a vehicle, they were accosted by the accused person armed with rods and other weapons like kukri rods, bullum, bullum, and started assaulting the informant with the intention of killing them. During such assault, it is alleged that during such assault, one person sustained various injuries. Full stop. During a coordinate bench of this court, by order 242026, has granted interim pre-arrest bail to all the accused,
Yes.
to the accused applicants, and with a direction to cooperate with the investigation. The learned counsel appearing for the accused applicants submits that in terms of the direction in order dated 242026, the accused applicants have already appeared before the IO and their statements have been recorded. Full stop. Next paragraph. In the meantime, the charge sheet in the instant case has been filed by charge sheet number is
White CS number 193/2026 dated 22/05/2026.
In view of the aforesaid, the learned counsel preparing for the accused applicants submits that they should be given liberty to approach the jurisdictional court, as they have already received the summons.
Yes, yes.
Received the summons for appearance on
2/9/2026. immediate.
2/9/2026. Full stop. Taking into account the aforesaid submission, the instant AV application is disposed of with a direction, to the accused applicants to appear on the next scheduled date before the trial court. Before the trial court. And till then, till their appearance before the trial court, jurisdiction trial court, okay? For the jurisdiction trial court, the interim order so passed on 242026 shall stand extended.
Fabulous.
So you appear on 29.
Yeah.
And then goes. Hmm?
Item 30.
30 Lordship. Charge sheet has been filed.
That's it, fine.
Yes. Dada. Dada.
No interim, huh?
Your Lordship, I'm only holding presence for the learned counsel.
Hmm?
I'm only holding presence for the learned counsel, and have no further instructions.
Who is the learned counsel?
Tisom.
Oh, no, she said that like so we can pass the order in the morning.
Lordship.
She wanted to bend out
Lord.
for this thing. Okay. Your name?
My name is Timjan Tila.
So and so on behalf of MST Som, the learned counsel, appearing for the accused applicant. When you write, also heard SH Bora, learned APP for the state. This is an application under section 482 of the NSS 3023, paying for granting pre-arrest bail to the accused applicant in connection with Gauhati police station case number 50/2026 under section 61 in bracket 2. Stroke 318 bracket 4, stroke 316 bracket 2, stroke 303 bracket 2 of VNS 2023. The allegations as merited in the FIR, that the accused applicant and another person, namely Rujiti Das, had taken the vehicles on rent from the informant on agreement of paying rent, and after paying rent for some time, stopped paying the same and did not return the vehicles as well. In terms of the aforesaid FIR, Gauhati police station case number 50/2026 was registered. The learned APP submits that charge sheet in the instant case has already been filed by charge sheet number 185/2026 dated 28/7/2026. In view of the, you require this?
No, no,
In view of
Will be
the
kept as a part of the
applicant, the learned
record.
counsel appearing for the accused applicant submits the liberty should be given to the accused applicant to appear before the jurisdictional, before the jurisdictional court. Full stop. In view of the aforesaid submission, the instant AV application is disposed of with liberty to the accused applicant to approach the jurisdictional court for appropriate relief, comma, if so advised.
Much obliged.
May please, Lord.
Here also the
Interim is.
You have appeared.
APR.
Hmm?
APR.
Heard Mr. J. Islam,
Yes.
London Council appearing for the accused applicant, also heard MSSH Bora, London AP for the activities and application under section 282 of BNSS 2023, claim for granting clearance bail to the accused applicants. In connection with Vilasi Para PS case number 105 stroke 2026, registered under section 331 bracket 6 stroke 309 bracket 6 of BNS 2023. The learned MSSH Bora, learned APP submits that charge sheet in the instant case has been filed before the jurisdictional court by charge sheet number 235/2026 dated 26/7/2026. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that liberty should be given to him to appear before the jurisdictional court for appropriate relief. In this, accordingly, the instant AV application is disposed of. No, it is seen that accordingly, it is seen that the coordinate bench of this court by the order dated 14/5/2026 has granted interim PRS bail to the accused applicant with a direction to appear before the investigation officer within 7 days. It is submitted that in terms of the aforesaid direction, the accused applicant has already appeared before the investigating officer and his statement has been recorded. In view of the aforesaid, the instant AV application is disposed of with the liberty to the accused applicant to appear before the jurisdictional trial court within 15 days, comma, for appropriate relief, if so advised, and till his appearance within 15 days, the interim clearance bail granted to him by order at 14/5/2026 shall stand extended.
Highly obliged.
32 also lordship charge sheet filed.
Order, but the interim order, not they appeared before the not concerned.
Okay, heard Mr. MU. Mr. Mahmood appeared over earlier.
My lord, no, my lord, myself.
Your name is recorded as MU Mahmood. Heard Mr. MU Mondal, the learned counsel appearing for the accused applicant. Also heard SH Bora, learned APE for the suit. This is an application under section 452 of BNSS 2023, praying for granting bail to the accused applicants in connection with Agomoni PS case number 16/2026 under section 316 bracket 2 stroke 318 bracket 2 stroke 318 bracket 4 stroke 308 bracket 2 stroke 74 stroke 75 stroke 351 bracket 2 stroke 3 bracket 5 of BNS 2023. The learned APP MSSH Bora, learned APP submits the charge sheet in the instant case has already been filed by charge sheet number 16/2026 dated 28/3/2026. Also, in view of the aforesaid, the learned counsel appearing for the accused applicants submit that liberty should be granted to the accused applicants to appear before the concerned jurisdiction court. Full stop. Within 15 days, about within 15 days, within 15 days appear will get disposed of. Same in last paragraph. Dispose.
Has been made absolute, earlier interim order.
No, you go and appear.
Will-
15 days I have given, 15 days time, you go there, appear.
On appearance, they may be released on bill, otherwise,
15 days I have given, 15 days you go there.
after appearance before the trial court, my lord.
After trial court will decide what is to be done.
In accordance with
Because
law.
search is filed, that means prima facie materials are there. So I mean, 15 days time is there. So you
But-
go and appear, we will consider it.
Obviously. 33.
33 also, Lordship, same prayer, such it has been filed.
I appeared.
You are in interim.
Yes, Lord.
Your name?
A Mena, Lord.
Or Mr. A. Mena, the learned counsel appearing for the accused. Appearing for the accused applicant also heard Mr. MS SH Bora on APP for the state. This is an application under section 482 of BNSS 2023, praying for pre-arrest bail to the accused applicants in connection with North Lakhimpur Police Station case number 76/420/406/409 of Indian Penal Code. Full stop. The SH Board and APP submits the charge sheet in the instant case has already been filed by charge sheet number 179/2026 dated 26/6/2026. Full stop. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that liberty should be given to him to approach the jurisdictional trial court. Full stop.
Yes.
It is seen that wide order dated 5/6/2026, a coordinate bench of this court has granted interim PRS bail to the accused applicant with a direction to appear before the investigating officer within 15 days. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid dated 5/6/2026, the accused applicant has already appeared before the investigating officer and his statement has already been recorded. Just taking into account the aforesaid, this court disposes of the instant baby application with the liberty to the accused applicant to appear before the jurisdictional trial court within 15 days, 15 days for appropriate relief, if so advised, and till his appearance within 15 days, the interim pre-arrest bail granted to the accused applicant wide order that 5/6/2026 shall stand extended.
Give the word.
34.
That is a substitute government.
Started submitted.
Substitute TCR didn't receive, my class officers are. TCR was called for that, it was received.
So we will, after perusing the PCR, we'll cancel it. And what do you want? You want to approach the trial court or what?
Well, I have no intimate.
You don't have any influence.
If I approach my lord,
So you want to approach the trial court or like you want, I mean,
was considering of the materials on record, my lord.
You have to peruse the system.
Because if I appear, my lord, then no, I have taken custody of my lord.
that I don't know. I mean, that I don't.
That time that TCR has been good.
The only thing is that like a choice is yours. I mean, you can go there also and like you can.
Also look into my lord, whether the injury is grievous or not. Yeah. As per my instruction, the both parties suffered some minor injuries.
You've written here injury report, I'm not finding. Find out, there is no injury report
My
here.
lord, we'll go through, my lord, after some time, my lord.
No, check it if you can, I mean,
Why
you
not?
can dispose it of unnecessarily. Small this.
Okay.
But I don't know, they have indexed the injury reports they have mentioned, but like inside I could not look at.
Thank you.
Serial number 6, it says index, but out there I could not look at.
The sachet is mentioned, my lord, but the appropriate may not be available. It is not with the TCR, my lord. It is not with the TCR.
TCR was called for by injury report, they haven't sent, they made the index, but like this thing not there. You are in interim?
No. No, the accused, my lord, he has been shown absconder in the search sheet, my lord. Accused has been shown as an absconder in the search sheet.
Correct, but like thing is that like, I mean, that is fine, but
And search sheet is filed also under section 1182 and 1091, my lord.
But injuries is UVS matter, then I have no case. In this matter, my situation.
only the injury doesn't matter. There are other materials also, are also relevant. We will call for the injury report.
My lord.
Heard Mr. A. Khoniker, the learned counsel, appearing for the accused opinion, also heard Mr. Ajay Borua, learned ATV for the state. Though PC, scan copy of the PCR has been received, the same does not contain the injury report of the victim. Registry to call for the injury report from which court is this?
From the session judge, my lord.
No, my lord, the CGM, my lord, Gulaghat.
From the CGM Gulaghat. Let the matter be fixed on. When?
My
Bodwa,
lord, 10th of September, my lord.
10 September.
Give them.
Does it anticipate will be the last time that the up-to-date case diary was called for?
My lord, 35 case that is not received, my lord.
This is not a appointment person,
Hmm?
not a appointment person. The chief time does it schedule. What time does the up-to-date schedule not available?
What was the allegation?
FIL page 7.
I mean, the earlier city received, my lord, but after it was called for, my lord.
Okay, this case, you'll have to wait for some time. Heard Mr. L. Gogoi, the learned counsel, appearing for the accused applicant, also heard Mr. R.G. Bodwal and AP for the state updated case diary. As called for is yet to be received.
Yes. Oh, sir.
Let the matter be fixed on. You get it, Mr.
My
Bodwal?
lord, on 7, my lord. 31st, my lord, 31st,
31st. You get it updated, see that.
my lord.
Right, thank you so much.
Okay.
Your lordship, pre-arrest bail application. I was granted the privilege of interim protection, my lord. I have duly appeared, my lord.
Hmm.
And CP was called for, I'm informed that it's been received, my lord. That would suffice, otherwise I have some contentions. The only non-bailable provision that was imposed upon me was 74, my lord. It was earlier 354. My lord, assault with the intention of outraging modesty, my lord. But actually, I had gone to my lord, chasing after them to hit them, my lord. That I have come with clean hands, because my lord, they had sexually assaulted my daughter, my lord, 15-year-old daughter, and threatened to parade her.
State. There is an application under section 482 of BNSS 2023 paying for granting pre-arrest bail to the accused applicant in connection with dispute PS case number 420/2026 under section 329 in bracket 4/74 115 bracket 2 315 bracket 3 BNS. The allegations as made in the FIR. The allegation as made in the FIR is that the accused applicant entered the house of the informant and physically assaulted the informant's family members, as a result of which the mother-in-law of the informant sustained injury on her neck and arm. On receipt of the FIR, police registered the police station case number 420/2026 under the aforementioned sections. This court, a coordinate bench of this court by the order number 26/6/2026 has granted interim pre-arrest bail to the accused applicant with a direction to the accused applicant to appear before the investigating officer within 10 days. Full stop. The learned counsel appearing for the accused applicant submits that in terms of the direction dated 26/6/2026, the accused applicant has already appeared before the investigating officer, and his statement has already been and his statement is recorded. Full stop. Full stop. CD in the instant case has been received, and the same is perused. Taking into account the fact that the accused applicant has already appeared before the IO and is fully cooperating with the investigation. This court is of the opinion that the interim pre-arrest bail granted to the accused applicant by the order dated 26/6/2026 should be made absolute. Accordingly, the interim pre-arrest bail order dated 26/6/2026 is made absolute, and the instant AV application is disposed of accordingly.
39, my lord, search is submitted. Investigation complete.
You were in interim,
I'm an interim.
No, and sections.
so you go and appear there. You go and appear, you are entering, okay?
One section is non-bailable.
You go and appear, approach there. Heard, Mr. Your name?
Are they?
Heard Mr. R.D. Land Council appearing for the accused applicants. Also heard Mr. R.J. Gurwal and an APE for the state, raised an application under section 42 of BNS 2023. Paying for granting PRS bill to the accused applicants in connection with Ram Police Station case number 55/2026, corresponding to GR number 499/2026 under sections 126 bracket 2 stroke 117 bracket 2 stroke 74 bracket 3 74 stroke 3 bracket 5 of BNS 2023. The learned APP Mr. R.J. Burwal and APP submits the charge sheet in the instant case has already been filed. While charge sheet number
I charge sheet number, my lord, 53/2026,
dated
dated 36/2026.
In view of the aforesaid submission of the charge sheet, the learned counsel preparing for the accused applicant submits that liberty should be given to him, given to the accused applicants to approach the jurisdictional court. Then you write the same paragraph. 15 days, within 15 days you appear there. 15 days, and till that time this interim order. It will be filled up, the interim. It will be the interim order this level 26. If I say, then you write a coordinate bench of this court by order letter 26/6/2026 has granted interim PRS bill to the accused applicants, and it is submitted that in terms of the aforesaid direction, the accused applicants have appeared before the IO, and their statements have been recorded. Yes, recorded. Full stop. Then you put in view of the aforesaid, the instant the application is disposed of with the liberty to the accused. Same paragraph. Same paragraph. We got 15 days and then disposed of.
I'm extremely sorry for making an out of turn mention. Item number 56, can it be adjourned for today? I had taken the consent of the other side as well.
56.
So the last hearing item.
Okay, on the prayer of the learned counsel, on the prayer of Mr. R.J. Das, the learned counsel, appearing for the petitioner. Let the matter be listed. When do you want?
Lordship, and any,
Let the matter be
9th of September.
Let the matter be listed on 23rd September. 23rd September, he submits that he has already taken consent of the counsel appearing for the respondent.
Deep level.
Made, please, Your Lordship. On the last occasion,
Report received. Okay, Mr. I. Borthakur is present for the accused applicant. Stop. Then you write, Mr. K. Vaishnav on APP submits that report as called for by the order rated 772026 has not been received as yet. Full stop. Let the matter be listed when. Let the matter be listed on 25th August. 25th August. Interim order so posted shall continue till the next list.
apply.
41.
PRS sale application, I am in interim and my statement has already been recorded. In fact, I am not a name accused. And I am a common employee. I am going to retire after 6 months now. And in fact, my lord, I am being told, my lord, that name accused. There is a specific allegation against the one Mr. Vidhu Koman, who has been granted bail by the learned court below. Although I don't have any certified copy. But I think but I have already, my statement has been recorded now. Inspector of school lost the.
You work as what?
He work as a, my lord, planning and statistical officer in the office of the inspector of school. Planning and statistical officer.
Mr. Sharma?
They're going to the merit structure, the entry, 2826 structure indicates structure that he has not appeared before the ILA. Because he was granted interim on 20 of July, if I'm not wrong.
But I am being told that he has already appeared on.
Let them file a created document based on the because if not motion coming, he has not.
He has not appeared, then we'll have to cancel it, Mr.
My lord. He has appeared, my lord, two date, my lord. One is 6th, my lord, as mine told, my lord. If required, I'll file affidavit, my lord. Six. On 6th August last he appeared.
Within 7 days. He is on leave, it seems, and he has not appeared.
No, my lord, I have to take instruction on that, but my lord, he already appeared, my lord. If required, my lord, on that effect, my lord, I'll file affidavit.
You file an affidavit then.
My lord.
Heard Mr. T.J. Mohanto, Learned Senior Counsel, assisted by MS M.K. Brown, the Learned Counsel for the accused applicant. Also heard Mr. B. Sharma, Learned APP for the state. A coordinate bench of this court by order dated 27/2026 granted interim pre-arrest bail to the accused applicant with a specific direction to appear before the investigating officer within 7 days from the passing of the order dated 27/2026. The learned APP referring to a GD entry dated 28/2026 has submitted that the accused applicant has not appeared before the investigating officer. However, the learned senior counsel, Mr. T.J. Mohanto, learned senior counsel, submits that as per his instructions, the accused applicant has already appeared before the investigating officer. Full stop. Taking into account the aforesaid, the learned senior counsel submits that he shall file an affidavit about his affidavit giving the details of his appearance before the investigating authority. Full stop. Let the matter be listed on 25th. 25th by the date, the learned counsel appearing for the accused applicant shall file the affidavit.
Interim order pass earlier shall continue.
Interim order pass earlier shall continue to give the state. CD2 ready. CD hasn't come. You were in interim, okay. CD not received. Interim order passed earlier shall continue till the next date of listing. Let the matter be listed on when, Mr. Sharma? 10 September.
Today is second date, my lord, for his day. Interim also not there. There is a one lady and one boy. FIR, your lordship, page 19. Not
No, we
out,
wait,
out
we'll,
of land dispute, man.
whatever, out of land dispute, he'll murder somebody over it.
Involvement of the lady, my lord.
Correct, I mean, whatever, I mean, there is no gender discrimination about this thing. Heard Mr. S. Ahmed, the learned counsel, appearing for the accused applicant, also heard Mr. B. Sharma, learned AP for the state. CD not received, let the matter be listed. When? Little bit at the early. 31st.
Second.
31st of August. 31st of.
Obliged.
You go and appear.
Yes, my lord. My lord, if I may say, my lord, I have the instruction that this is the FR probably, if I am not wrong, my lord.
Check
Yes, yes.
pictures. Heard Mr. Your name?
JC Bora.
Huh?
JC Bora.
JC Bora.
Yes.
Heard Mr. JC Bora, the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. Is an application under section 482 of BNSS 2023, praying for granting bail to the accused applicants in connection with Budagaon PS case number 40/2026. Budagaon PS number 40/2026 under section 331/305(3) of BNS. Where is the FIR?
FIR is at, my lord, that is at page, my lord, FIR it is at 37, my lord. In fact, it's a, my lord, land dispute, my lord. And my lord, this FIR has been lodged only with a view to, my lord, disposes me from the land.
An FIR was lodged on 26/2026 by the informant alleging inter alia, alleging that the accused applicants on 35/2026 FIR filed before Budagaon police station, police station, alleging that on 35/2026 the accused persons, by breaking lock and wall of the godown of the informant, had stolen certain jute, certain 20 men's what?
That is been, my lord, one mil is, my lord, 40 kg. my lord.
Huh?
One money is
Certain
40
amount, I mean, certain amounts of lentils, corn, and some quintals of corianders, etc. Also, the learned counsel appearing for the learned Mr. B. Sharma, the learned APP, submits the charge sheet in the instant case has already been filed by charge sheet number
62, dated 1/8/26.
The learned counsel appearing for the accused applicant submits that he should be given liberty to approach the appropriate court. He should be given liberty to approach the jurisdictional court. Full stop. Full stop. Taking into account the aforesaid, the instant AB application is disposed of with liberty to the accused applicant to approach the jurisdictional court, if so advised.
I will include it.
45. Next is an inquiry from the mission.
I will appear lordship before the police.
As Mr. S. Sutradhar is present, learned counsel is present for the accused applicant. CD is yet to be received. The interim, let the matter be fixed on.
14.
Huh?
14.
1/4. Let me little bit earlier.
Yes.
11th September. Interim order so passed earlier shall continue till the next date of listing.
Obliged.
47.
Made to me, lordship.
CDS.
Lordship, find the FIR as page 15, my lord. Page 15. Allegation is that, my lord, the petitioner along with one Onubora made a false claim of, my lord, PF settlement. Second claim was made and some money was withdrawn by Onubora. Is the allegation, my lord.
Submitting this communication. First, who is this Ranjit Bora?
Yes, Ranjit Bora is the person, my lord, who was, my lord, shown as a deceased, my lord. And from, my lord, the second, my lord, this PF settlement was made, my lord.
Ranjit Bora is still alive,
Still alive.
but death certificate has been given.
That was given, my lord, for the level. In this regard, two communications are there, my lord. One to the, my lord, that is the health department, my lord, that he is alive. Second, my lord, when they have come to know that second settlement was made, my lord, they write to the, my lord, that is the, my lord, Prohibitions fund also, my lord, in this case. Now, my lord, who is the accused petitioner? Accused petitioner Manoj Gogol. He is the PF platform. From his table, everything is made. Now, my lord, the my lord, money, my lord, which is deposited to one Onubora. Who is Onubora? Onubora is the mother-in-law of the said accused petitioner.
Manas Gogoi.
Yes, my lord, Manoj Gogol. So in this case, my lord, investigating agency, my lord, idea, my lord, legal objection. That is also I, my lord, my lord. Money trail is there, and he is in a, my lord, position where, my lord, show that, my lord, all these PF settlements were made. So they make it clear, my lord, in this case, how manner, my lord, in what manner this entire thing has, my lord, committed. For that reason, my lord, custody and interrogation is needed. That is my respectful submission, my lord. All sufficient, entire sufficient materials are available there, my lord. I have flag mark, my lord. From, my lord, that, my lord, death certificates, to, my lord, there is the bank account, my lord, details of Onubora and other, my lord, my lord.
One of the
Independent witnesses also.
FIR says Ranjit Bora expired on 31/8/2021.
But Ranjit Bora is there.
No, my lord. FIR says, my lord, paragraph 4 of the FIR, Lord, should kindly see. Paragraph 4A, as per 80 PF records, Ranjit Bora expired on 31/8/2021. Settlement after date is illegal. That is the case in the FIR. Now my friend is, my lord, submitting.
No,
the-
I mean, FIR was lost by whom?
by the manager, by the manager of the Malad.
Manager is
Garden.
the complainant, my lord. What he has, my lord, submitted based on record, my lord. If my lord on that part also, because the material available at that point of.
No,
time-
expired means like he has, because you have shown him to be expired.
Possibly kindly appreciate.
See, you have shown him to be expired, you have submitted a death certificate. Whereas Mr. Ranjit Bora has written himself that he is not expired, he is still there. Then what basis you have got the money?
My case is that, my lord, the Onubora, my lord, she made a claim.
Anubara is your mother-in-law, isn't it?
My lord, she submitted an application before the, my lord,
So
authority.
Anubara is not wife of Ranjit Das, Ranjit Bora.
That I am not aware, my lord.
Bad case. Heard Mr. AI Hussain.
My lord, what the manager himself, my lord, forwarded the proposal.
Hmm?
I just put, my lord, submitted the application before the competent authority.
Okay, let the investigation,
Made
but let the investigation be done. But at this stage, I don't think this is a fit case to be granted anticipatory bail. Let the investigation be done. Heard Mr. AI Soikia, the learned,
Ask, my lord, will appear.
no. Yeah, Soikia, the learned counsel appearing for the accused applicant, also heard Mr. K. Bushra, learned APG for the state decision application under section 482 of BNSS 2023. Paying for grant of pre-arrest bail to the accused applicant in connection with demo PS case number 74/2026 registered under sections 316/318 bracket 4 319 bracket 2 336 bracket 3 338 bracket 338 61 bracket 2 of BNS 2023. An FIR was lodged before the officer in charge demo police station 17/7/2026 alleging inter alia that the accused applicant who is a clerk, who is the PF clerk of Thara Police Estate, has fraudulently, in connivance with another person, namely Srimati Onu Bora, has had transferred to the account of MS Onu Bora, Srimati Onu Bora, the second installment of PF fund belonging to Sri Ranjit Bora, showing Ranjit Bora as dead. Full stop. It is also alleged. It is also dead. Full stop. Then you write on the basis of the FIR, police registered demo police station case number 74/2026. The learned counsel appearing for the accused applicant submits that the accused applicant is only the PF clerk, and he has done the needful on the basis of the advice by the manager. Full stop. He submits that the accused applicant is an employee and employee with the Thara Tea Estate.
My lord.
Thara Tea Estate, and he will cooperate with the investigation. Full stop. Case diary in the instant case has been received, and the same is perused. Mr. K. Bushra, the learned APP, on the other hand, opposes the bail prayer of bail, submitting that there are sufficient materials of forging documents and thereby fraudulently transferring the amount to the mother-in-law, namely Onu Bora, by the accused applicant Manas Gogoi, who is the PF account of Thara Tea Estate. Full stop. This court has gone through the case diary as well as heard the submissions made by the respective counsel appearing for the parties. Having found prima facie materials against the
Onu Bora, other co-accused, madam. She was served with a notice, madam, under 35.
No, whatever is there, I'm recording.
She has appeared
Let her appear. Let her appear.
Notice
Let her appear.
petitioner also, my lord.
Let her appear. I'm not granting any relief at this stage. This is not done. She can appear, go there. She is not.
She has appeared, my lord. She has appeared.
She is not before this court.
She has appeared, my lord.
She has appeared. Let her appear, but she is not before this court. So I'm not going to pass anything, any kind of this thing.
Submitting, my lord. Notice may be issued to us also.
No, not at all. Not at all. Having found prima facie incriminating materials against the accused applicant, this court doesn't find any merit in the instant case, and accordingly, the AB application is dismissed.
Obligement.
Other side is CBI.
Who is your senior? Okay, CBI. Okay. Okay. Mr. S. Bothakur Dalanek, Senior Counsel is assisted by so and so is present for the petitioner. Your name? Ms. P. Mojumdar, the Learned Counsel appearing on behalf of Ms. M. Kumari, the Learned Standing Counsel CBI. Praise for adjournment of the matter as
26,
26 will be too early. I don't think.
because it's pending for locking away.
September sometime.
Lots.
It is so many matters are there.
Lots.
Yeah.
On 2nd of September.
Right. What is done? On behalf of M. Kumari, praise for adjournment of the matter as he is occupied with another court. So, prayer of the Learned Counsel for the respondent CBI is accepted. Let the matter be listed on sometime on
9th.
9th September.
Okay.
21.
Please, Your Lordship. Lordship, if the matter be taken up in the next week, as my senior is on legs. My
Who is
senior,
your senior?
R.S. Mishra.
Where is he?
He is in Port 6. Port 6.
Okay, we'll give them some time. Says okay. Both the parties are duly represented on the prayer of the Learned Counsel appearing for the petitioner, which is not objected by the counsel appearing for the other side. Let the matter be listed on when?
Any day.
16 September.
Obliged.
May I please, Your Lordship? I filed this petition for passing of the complaint.
Scan copy has come.
Complaint petition along with your.
Respondent number 2 appearing. You are appearing respondent number 2. You are Nicholas Borua.
Respondent number 2. Respondent number 2.
You are Nicholas Borua. Yes.
Your Lordship, I filed this criminal petition for passing of the complaint along with the other technical organizations against me. What when in case, Your Lordships, defendant number of Your Lordship, this Nilkesh Barua is the husband, and my sister, Your Lordship, she is a Srimati Archana Bhattacharya, his wife. There is
Your sister is his, respondent number 2's wife.
Wife, Your Lordship.
Okay.
Yes. So there is a dispute in between the sisters and Your Lordship, the husbands.
Dispute between husband and wife.
Wife.
That means your sister and her husband. Yes.
It's led to Your Lordship filing of the DB case. And other proceeding was also pending. Accordingly, DB case was filed. In the DB case, Your Lordship, there is an order of the Learned Trial Magistrate that upon my applications, being the Your Lordship, my sister applications, that visitation that is required. Your Lordship.
Why you have filed this? Why your sister is not before this court?
No, Your Lordship. I am before this court, Your Lordship, as a brother. The allegation is that I am my sister eloped with his own son, and I have a sister too.
What, I mean, allegation is?
My sister, that is the wife of this respondent number 2, aloof with her own son.
What kind of allegation is there? Okay, then what?
And I being the maternal uncle of the child and the brother of the sister assisted her. This is the allegation. This allegation is not in the complaint, you know. My role is nowhere there in the complaint regarding the objection and all the allegation you know brought wrongful confinement and all, you know. But learned trial magistrate in this case taken cognizance against me under section, your lordship, 49, 61, 2, 127, 4, 127, 6 of BNS, your lord.
49,
49, 61, 2, 61 bracket in bracket 2, your lordships, 127, 4, and 127 bracket in bracket 6, your lordship, BNS. Your lordship, I want to draw your lordship attention to the page number 11, complaints. Complaint, your lordship.
one thing, let us check the sections.
Your lordship, section 49 is
Punishment for abatement.
Abatement, your lordships.
61.
61 is a conspiracy, your lordships. Criminal conspiracy, your lordships. And 127 is a wrongful confinement.
Yes.
Your lordships.
Which page you said?
Your lordship, page 11.
Page 11 is the initial complaint.
Complaint petition. Your lordship, allegation the start from page 12. I may read, your lordship.
Read slowly.
That the complainant and accused number 1 are the husband and wife.
One second. Complainant is Mr.
Respondent number 2.
Nikhilesh Borua.
Your lordship.
An accused person, Archana Bhattacharya, deputy so and so, so and so.
Archana Bhattacharya is the wife.
Devasis Bhattacharya and so on.
Your
Okay, okay. The complainant and accused number 1.
Husband
Okay.
and wife in relation, they had been living in Mumbai, Maharashtra for long in company services. On 17/4/24, the complainant and the accused number 1 along with their minor son Upanshu Barua come to the complainant's parent residence at village Goremari, Moja Goremari, PS Tezpur, district Sonalpur, Assam. After arrival at Goremari, the complainant saw the precarious condition of his old ailing father and mother, who are aged about 80 years and 72 years respectively, and having seen the situations, the complainant decided not to go back to the Mumbai again, because there is none but the complainant in the family to look after his parents. But when the complainant told the accused number 1 about his reason of not going to the Mumbai back, the accused number 1 became furious and started quarreling with the complainant, and after constant quarreling with the complainant for about a month, the demanding to go back to the Mumbai, the accused number 1, Archana Bhattacharya, left the complainant residence on 24/5/23, went to her parent residence at village Chuburi, Dekargaon, under Moja Haleswar Police Station, Tezpur, district Sonitpur, Assam. Thereafter, not only the accused number 1, but also her mother, Srimati Jyoti Bhattacharya, accused number 2, elder brother, Devasis Bhattacharya, accused number 3, his wife, Srimati Sujata Bhattacharya, accused number 4, started harassing the complainant by scolding, revoking, abusing over the mobile phone. All the accused person has conspiracy against the complainant. The accused number 1 instituted a number of proceedings against the complainant in various forums. Accused number 2 even threatened the complainant with murder. And finally, the accused number 1 instituted CR case number so and so DB case, your lordships, 748 to 2020 in the court of Chief Judicial Magistrate Sonitpur at Tezpur. In course of trial on 28/3/24, the accused number 1 filed a petition in the court saying to grant her a right of visitation at least once in a week to her son Upasna Barua, who has been in custody of the complainant, and with the consent of the complainant, the court granted leave to the accused number 1 to visit the child at the house of the complainant and take him to her palace on every Sunday and drop him back in the custody of the complainant before sunset on the same day. Accordingly, as the leave of the court, since the month of March 2024, the accused number 1 had been visiting and taking the child and dropping him back in the custody of the complainant till the month of September 2024. But on 6/10/24, the accused number 1 took the child to her place and has not dropped him back in the custody of the complainant, yet as required by the order of leave of the court. On 7/10/24, the next day, the complainant filed an application in the court informing the matter and praying for order directing the police to recover the child, drop it back in the custody of the complainant. On a hearing for the complainant, the court passed order directing the Tezpur police to make inquiry and trace out the child, and if they found to drop it back in the custody of complainant, but the Tezpur police could not recover the child and drop it back in the custody of the complainant yet. And on 14/2/24, the court dismissed the said CR case number so and so for default of the accused number 1. On 7/10/2024, the complainant also lodged an FIR with the Tezpur Sudar Police Station against the accused person, but police refused to take any action upon FIR of the complainant. Complainant believed that the accused number 1, with the motive of cheat, the complainant played fraud not only upon the complainant but also upon the honorable court. Accused number 1 did all these acts and deeds with the help and abatement of other accused persons. The accused person having certainly committed offense under section so and so. This is the complaint. Here, lordships, in fact, the same substance in this case, your lordship, a order was passed in a DV case, which was later on dismissed for default on absence of the accused number 1, your lordships. This order was violated. Violated by the accused number 1. I am the brother of accused number 1. I have no role. Or court has passed an order to take back his son and drop it back in one Sunday. And this is going on in one day. Always taken by the son and look. But she is not traceable as of today, your lordship.
She's not traceable till now.
Yes, your lordship. She is not traceable.
But he's appearing, he knows where she is. Huh?
You know.
Oh, he knows.
I don't know, your lordship. I have filed my so-called notice, so-called before the trial court, your lordship.
Huh?
In so-called, I have said that I have no knowledge where she is. So, sum and substance, your lordship, it is the allegation of this taking the child by violating the order of the court by the mother. Now, the question arose whether mother can abduct her own child, on biological child.
No, you are not appearing for the mother.
And then, your lordship, the whole allegation is against the mother. Now, where I came, your lordship?
Where is the order? Impure order.
Your lordship, order is as page 24, your lordship.
Page 24. Yes.
Your lordship. Mary, your lordship.
Yes.
Complainant is present along with his learned counsel. Accused person Jyoti Bhattacharya, Devasis Bhattacharya and Sujata are absent with a step by petition number so and so showing cause of absence. Seen heard today was fixed for order. Seen the case record heard both sides. Learned counsel for the complainant submitted that the accused side is voluntarily relying the matter knowing fully well that the allegations are serious in nature and that the prime accused Archana Bhattacharya, who violated the order of the court and kidnapped the minor child who was in the custody of the complainant in spite of knowing
about the act of said crime accused. Other accused are taking the benefit of the law and have not appeared to submit the cognizance on cognizance. Moreover, the so-called submitted by them has no relevance and that petition has been filed on behalf of Archana
What is
Bhattacharya.
this so-called submitted by them means what?
Your Lordship, pre-trial so-called, Your Lordship,
Okay.
Reply to this.
sorry, reply to the so-called, Your Lordship.
Mm.
Confirm her presence and so cognizance can be taken in this case. Learned counsel for the accused number 2, 3, and 4 and other had admitted that the hearing on cognizance cannot be take place without the presence of all the accused persons. Since the so-called filed by the accused number 2, 3, and 4, which state that the accused number 2 is an old lady and she is confined to bed as she was suffering from paralytic attack since 7 and 8 years. She cannot walk and is totally dependent upon her son and daughter-in-law. It is further stated that the accused number 1 is the lawful married wife of the complainant, and after marriage, both of them began to reside with her husband in Mumbai in rented accommodation, establishing therein her independent matrimonial households, and other accused person never interfered with the matrimonial lives of both the complainant and accused number 1. It is further stated that on 24/4/2023, the complainant and his family come down to Assam to attend the wedding of the relative, and that the ticket for the complainant was arranged by his sister, who did not arrange any ticket for the accused number 1 and the child. The complainant is stated to be unemployed and that the only earning members of the house was Srimati Archana Bhattacharya, accused number 1. It is stated that in spite of having a confirmed ticket, return ticket, the complainant refused to return to Mumbai, causing financial loss to the accused number 3. It is stated that thereafter some family dispute arose and the complainant dropped the accused number 1 from his house and forcibly kept his son with him, for which the accused number 1 had to return to his house and she was not allowed to meet her sons, for which she filed a custody case, and court allowed her to maintain contact with her sons on a weekly basis every Sunday. On 6/10/24, while proceeding to the complainant residence to meet her son as per the court instructions, the accused number 1 suddenly went missing with her minor son, and every possible effort was made to trace the accused number 1, for which the missing person complaint at Kachari Gaon PS was made. It is stated that the accused number 2, 3, and 4 are not involved in the sudden disappearance of the accused number 1 and her son. That the complainant has filed this case in order to harass the other accused persons in the document filed along with the so-called. Section 223 BNS provides that the magistrate having a jurisdiction while taking cognizance of an offence on complainant shall examine upon oath of the complainant and a witness present, if any. Substance of such examination shall be reduced to writing and shall be signed by the complainant and witness and also by the magistrate, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. On going through the entire complaints and the statements of the accused oath, it appears that the allegation against the accused number 1 is that she had taken the minor son of the complainant along with her from the lawful custody of the complainant on 6/10/24, but did not return with the said minor sons as per the order of the learned SDGM Sonitpur, Tezpur on 28/3/24, whereby violating the order of the case by the accused number 1 herself. Missing accused number 1 along with the minor son also been admitted by the accused number 2, 3, and 4 in their so-called. Further on, going through the statement of the complainant and the witness on oath, it appears that the accused number 3, Devashish Bhattacharya, was seen with the accused number 1, Your Lordship. This is the only allegations. And minor son in the car on the very day when the minor son along with the accused number 1 went missing, Your Lordship. So this is the only allegation brought. That is nothing in the complaints, but it may be on oath, Your Lordship. So this allegation, I am posing for the
This has come from where? In the so-called reply?
From the complaint.
Huh?
It is not from the complaint. And there is no item of any sentence, Your Lordship. Your Lordship, whatever be the witness say before the Your Lordship trial courts, Your Lordship, even in the initial deposition, Your Lordship, there must be some foundation in the case made out before the court, Your Lordship. But regarding this fact, Your Lordship, the allegation is that it appears that the accused number 3, Devashish Bhattacharya, was seen with the accused number 1 and the minor son in a car on the very day when the minor son along with the accused number 1 went missing. So this part is not in the complaint, your lordship.
Then what is it?
Then your lordship, hence appear that there is a prima facie material exists against the accused number 1, Archana Bhattacharya under section 127(4)(6) BNS and accused number 3, Devashish Bhattacharya in the instant case under 49, 61(2), 127(4) and 6 of the BNS. So this is the cognizance taking, your lordship. Thereafter, your lordship, the address in the complaint for the accused number 1 is same as that of the accused number 2 and 3 and 4. The copy of the notice issued to her has been received by accused number 3 on behalf of accused number 1. The notice containing the signature of accused number 3 will show proper service of summons. Now, perusal of the case record revealed that the bad petition number so and so, it is stated that Archana Bhattacharya is bedridden for last 6 to 7 years. However,
Archana Bhattacharya is not bedridden.
no, she is not bedridden. Bedridden is Jyoti Bhattacharya.
Oh, so it is wrongly written.
Yes, your lordship. However, none come to clarify as to same reason why reason has been mentioned for Jyoti Bhattacharya, that is a mother, in the so-called. The said petition sought for adjournment for the appearance of accused number 1, which was allowed by the order of so and so. Said Archana Bhattacharya did not appear, which does lead to say that the accused number 1 has no intention of appearing in this case. The instant matter is stay till the hearing of the accused number 1 indefinitely due to her non-appearance, as is seen from the conduct and from the submission of the learned counsel for the accused side. There will be prejudice of justice not only for the complainant but also for other accused persons. To the opinion of the court, in the spirit of section 223 of BNS is not to delay the proceeding for the absence of one of the accused for a long period of time, but to check the veracity of the claim of the complainant and to decide whether to proceed and how the allegation itself is the accused number the allegation itself is the accused number 1 has taken their minor son away from the complaint by violation of the order of a proceed learned court number DGM Sunitpur Tezpur is now missing. So further waiting for her appearance, more particularly when it appears that she has made an appearance, that petition that is so and so would serve no purpose, would go with the spirit of section 223 of the BNS. Hence, this court has no other option but to take cognizance against accused number 1, Archana Bhattacharya, under section 127(4) and 6 BNS, and accused number 3, Devashish Bhattacharya, in the instant case under section 49, 61(2), 127(4) and 6 BNS. However, there are no prima facie materials found against accused number 2, Jyoti Bhattacharya, and accused number 4, Sujata Bhattacharya, under section 49, 61(b), 3182 and 3513 of BNS. Hence, no cognizance taken against them. Complainant is to take a step for issuance of summons upon the accused number 1 and 3. It is need mention that by petition number so and so, it is submitted that the accused persons are out of the station in Gauhati to pay the last homage to the departed soul of the legend Jubin Garg and were unable to attend the court today, to which this court has pointed out to the learned counsel of the accused person as to the cause of his absence of the accused number 2, as she was stated to be bedridden for many years, and learned counsel Sri Tapas Ghosh had submitted verbally that the absence of accused number 2 as per the earlier reasons, also admitted that the medical document has been submitted earlier, which are not by the court. However, later on, at the time of writing of the order at around 4 p.m., it is seen that the learned counsel for the accused had added about the absence of the accused number 2 in petition number so and so, after it was submitted in the court without the permission of the court, more so when the court did not ask for any further explanation or to mention it in the petition, which is not warranted. The learned counsel Sri Tapan Ghosh is hereby strictly directed to be refrained from doing such an act further. So this is the order, your lordship. Here the order, the only allegation, your lordship, written complaint and order, is that somebody seen me with my sister, with the son, on that particular date. For the sake of argument, your lordship, on the particular date. From the sunrise to the dawn, your lordship. It is the legal custody in the hand of my sister, your lordship, as per the order of the court, your lordship. And maybe I was there. For the sake of, I was not there, your lordship, even for the sake of argument, your lordship. If anybody seen me in the day, your lordship, that doesn't amount that I am complicit with my sister to take his son, your lordship. Only this part. Whether for that a case, a criminal case can be put in motion against me, your lordship. My humble submission, your lordship, upon only this
two lines, your lordship, which may be found in the initial depositions. A criminal case cannot be set in motion against me, and that too, your lordship, from during the period of legal, your lordship, permissions. If at all anybody seen me, your lordships. And moreover, your lordships, there is no genesis of this part, your lordship, in the complaint case. Nothing is there. The complaint has not said anything regarding that. They improved in the, your lordship, initial deposition and deposition before the learned trial court, your lordship. So my humble submission, your lordship, there is nothing in the case which implicate me with kidnapping and anything, your lordships. So I pray for discharge, my discharge, your lordship, from this case.
Kidnapping is not alleged against him.
No, kidnapping is not alleged. Actually, allegation is wrongful confinements,
And
criminal conspiracy,
abatement.
abatement, your lordship.
Abatement.
All these three. Even abatement is also not there because they have not said so, your lordship. Even complaint they have not said so. All along they are saying that legally my sister has taken the sons. But later on she aloof with her own son, biological son, your lordship. This is the situation. And now I am wrongly, this way your lordship implicated in this case, your lordship.
If you use the word elope, it gives a different meaning.
So, your lordship, my humble submission, your lordship, I am no way related. There is no complication, nothing, your lordship. And upon only this statement, also, I cannot be brought into the criminal case, your lordship. This is my humble submission.
Yes. Yes.
Lordship, and we know to something better. The lady with the wife or accused number one is missing till date. There is no recovery. And she was last seen on that day with the petitioner or accused number two, or brother. Accused number three, or brother. And the witnesses produced by the complainant, the respondent number two. The names are mentioned in annexure 1.3.11. One Pulokesh Gogoi and one Sudipto Borua, who were examined, my lord. In terms of that provision of law, my lord, as has already been laid out, my lord, in 223, my lord, where it is allowed for examination of witnesses.
Sudipta Borua and Pulokesh Gogoi.
Pulokesh, those are the witnesses. And after going through the manner, their deposition, manner, the court has held, manner. At page 26, as has already been placed by my friend. Further on going through the statements of the complainant and the witnesses on court, it appears that the accused number 3, Devasil Bhattacharya, was seen with the accused number 1 and the minor son in a car on the very day with the minor son alone with accused number 1 when number 1 went missing. My lord, as you also please aware, and also with several pronouncements, it has been laid down by the Supreme Court. So the press information is not an encyclopedia. It may miss out so many facts and all details. But later on, when it comes to the notice of the court, then the court is hands in jurisdiction. And till date,
Is there any police investigation in the case about the missing?
Initially we filed an Ezra.
Then what happened to that?
But nothing, they didn't take it. Then we filed the complaint. We have stated here.
The complaint you have filed,
After filing the FIR or the Ezra with the police, when they did not act, then we have to file this complaint. And your lordship is very serious, my lord. The order, I have a copy of that visitation order with me. I mean, see, the visitation order to the child, my lord, given to the mother in the other proceeding.
DV proceeding.
DV proceeding, my lord. And then, my lord, being away with his son. This is
But his involvement is only saying, how abatement.
Implicit involvement is there, but
Implicit involvement.
On evidence, my lord.
The
on evidence.
Abatement.
On evidence.
Wrongful confinement. How?
On evidence, my lord. My lord, this contradiction can be brought to get, later on, my lord, he may get relief, my lord. But,
The
with your
pri-
lordship after taking.
In a
this
prima
cognizance,
facie,
Yes, but prima
abatement, wrongful confinement, what? What is the allegation against him? When he has wrongfully confined somebody,
my lord, now we do not know, my lord. I mean, they were last seen.
there has to be some material. I
No,
mean,
yes,
I mean, if you say do not know,
No.
then you allege that like, oh, he has done a wrongfully
This
confined.
Can be, my lord, replaced or my lord.
Section camera, that is what.
My lord,
Next.
by the court at any time, my lord.
Understood, that is understood, but like
Yes,
to bring in some prima facie material, you have to bring in some material showing that okay, wrongful confinement was there, showing that like okay, criminal conspiracy, one thing like okay, I mean at this stage okay, I mean we do not know, but wrongful confinement, abatement,
Wrongful confinement.
abatement of what?
My lord.
Abatement of what?
Abatement to the act of wrongful confinement of the child. Abating his sister. Now, my lord, the basis of this is the evidence adduced by the witnesses, which is already recorded. Your lordship may call for the record.
The call for record is there.
Your lordship.
Yes,
Yes, that, my lord. And only one, my lord, page 5, my lord. If your lordship will kindly.
Page 5.
Yeah, page 5 of his petition. Para 8. This is his clear admission, sir. Para 8, page 5.
Yes,
Last line, man.
that the accused person certainly committed offences.
Under section 12 of the law.
Your lordship,
This is his lordship. Will be given. Then even before that, my lord, the complainant believes that I think it should have been petitioner, believes that the accused number one with a motive to cheat the complainant. They force not only upon the complaint but also upon honorable court and accused number. But this second line, my lord, that the accused persons have certainly committed offences, and this was filed on 4th February, if I am not mistaken.
Your lordship, I am clarifying to this point. These are the statement you have made in the complaint, your lordship, reproduced before this noble court. And I have also annexed the complaint petition hearing, your lordship. It is the language of the complaint petitions. As it is, I am given, your lordship. It is not my admission.
But the way you have drafted it,
This line is
that
very
may
clear,
looks, that may,
that the
your lordship.
no, that is he has copied from the complaint.
I don't know. I don't.
Yes,
One-
the FIR complaint the complainant has
It is
been
complaint.
complaint has been given me.
We cannot assume about my lord.
No.
Publicity, the act, my lord, how can we assume that this was not, this is what is statement? Well, my humble submission is that your lordship will go through the report, whether the evidence that has been used.
We'll go through it. Any more submissions here?
No, my lord,
Okay,
prima facie satisfaction of the court below, my lord, the primary court, my lord. And replacement by the higher court, my lord, there are cases, my lord.
But I mean, there's something cannot be perverse.
And so far as the sections, my lord, are concerned, my lord, this addition, my lord, the lordship can always modify it at any stage of the trial, or the higher court can also do it. This is at the very initial stage. This is only cognizance, my lord, charge is yet to be framed. Then trial has to be proceeded with. I have not gone through the matter, I know just copy of the evidence additionally testimony. And it cannot be reduced to a mini trial, my lord, at this stage, man. That is my humble suggestion.
But cannot be an abuse of processes.
My lord,
Cannot be an abuse of Process also.
No, you know, process, well, he has followed it. Maybe the sections could have been something else. Then charges get to be framed, only permission of the case. No.
Where is this person, Devashish Bhattacharya now?
No, Tezpur University.
He was arrested. He is
No,
released.
he is not arrested.
Huh?
He is not arrested.
Huh?
He is outside also.
He?
Devashish is outside.
He was arrested earlier.
Earlier
Now he has been released.
He released also.
NBW was issued against him due to inadvertent mistake. In the complaint, there is no allegation.
Complaint, my lord, yes, my lord, I have to admit there is no allegation, but
There is no allegation, and only on the basis of one sentence, or that to see, I mean, what is the statement? Statement says that I went for servicing of my car. That person, the witness is saying, and while going near KFC Mission Sariali, Tezpur, I saw the car of Devasis outside the KFC. And Orchana and Upangsu were coming out of the KFC with a parcel in their hand. Devasis Bhattacharya and another lady was inside the car. That much.
my lord, this viewing will always be like that. Maybe in front of KFC or some restaurant or by roadside. it
Yeah,
is-
correct, but
so-
weaving one. I mean, only that he. I mean, the car was there, and inside the car, Devasis and one lady was there, and they have seen the. I mean, this accused coming with a car.
This is the only link available to the court for such a serious minor offense of violating the court's order. He is the only person who can minor explain minor the actual facts. Your lordship, I'll just point out minor two things. Man. Why? This is a very early stage, nation stage. Charge is yet to be framed. This is only cognizance. The Sometimes we also argue that it's a routine, my lord, ma'am.
Hmm.
The complaint or the charge sheet, whatever be the case,
Hmm.
my lord, the cognizance is taken, then my lord, process starts. Now, my lord, in this case, my lord, by the Supreme Court, my lord, 2023, my lord, CBI versus Aryan Singh, I would like to, my lord, read out.
No, it was-
4.1.
Citation-
I have got one copy, I'll hand it over.
Then the citation you give me?
Citation 2023 live law
Hmm.
within bracket SC.
Hmm.
292.
29.
Para 4.
What is name? What CBI versus?
CBI versus Aryan Singh. Except Aryan Singh. ARYAN.
Hmm.
Para 4.
There are 4.
From the impugned common judgment and order passed by the High Court, it appears that the High Court has dealt with the proceedings before it as if the High Court was conducting a mini trial, and though the High Court was considering the applications against the judgment and order passed by the learned trial for the conclusion of trial. As per the cardinal principle of law, at the stage of discharge and of quashing of the criminal proceedings, while exercising the powers under section 482 CRPC, this section is now different. The same power.
528 now.
Court is not required to conduct the mini trial. The High Court in the common impugned judgment and order has observed that the charges against the accused are not true. This is not the stage where the prosecution investigating agencies are required to prove the charges. The charges are required to be proved during the trial on the basis of the evidence laid by the prosecution investigating agency. Therefore, the High Court has materially erred in going in detail into the allegations and the materials collected during the course of the investigation against the accused. At the stage of discharge and or while exercising the powers under section 482 CRPC, the court has very limited jurisdiction and is required to consider whether any sufficient material is available to proceed further against the accused for which the accused is required to be tried or not. And then another minor citation. This is 2025 live law against Supreme Court.
2025?
2025 live law
Hmm.
within bracketed minor SC
Hmm.
675. Abhishek Singh versus Ajay Kumar and others.
Abhishek Singh versus?
Abhishek Singh versus Ajay Kumar and others. This is para 10 minor. Following another 2025 decision, my lord, Naresh Aneja versus State of UP. Here, what's it? This is available in this judgment. But I'll read out para 10.
Are you going to give me those cases? Okay.
Your lordship will ignore my markings first.
No.
A reference may also be made to the recent decisions of this court in Naresh Aneja versus State of UP, where it was held that there are 18 of that. There are 18 of that judgment.
That has been quoted. Okay.
That has been quoted.
Hmm.
It is well settled that when considering an application under section 482 CRPC, the court cannot conduct a mini trial, but instead is to be satisfied that prima facie the offences were released and made out. To put it differently, it is to be seen without undertaking a minute examination of the record that there is some substance in the allegations made which meet the threshold of statutory language. Not more than that. Then, well, here in this case, my lord, this is the cognition, my lord, when the charge pending of trial will it will come. And thereafter, my lord, trial will.
And accused number 1 is not there.
My lord.
Accused number 1 is not there.
Accused number 1 is very much there because of the evidences adduced by him by the PW.
No. I'm saying that like accused number 1 is missing.
She is not.
She is missing.
With child.
She is missing. So to
and he is the only link, my lord.
Only link to find out where the child and the.
That is my answer. And who and my mother and the sister-in-law, they have already been.
No cognizance taken against them.
And Niharika, my lord, you are watching Niharika infrastructure. I'll just read. Well, where it says, my lord, that the first information report, this is para, my lord.
Which case, Niharika?
The Niharika infrastructure. my lord. Para 23, conclusion. They have given up the various situations, 1, 2, 3, 4, 5, 6, 7, up to 12, 12 different situations have been discussed. In 12, my lord, it brings out the first information report is not an encyclopedia, which must disclose all facts and details relating to the offense report.
No, but I mean, I don't think like we will. I mean, Niharika's. I mean, this line is be applicable to this case. I mean, you know why I'm saying encyclopedia is something. Encyclopedia is. I mean, like, we have seen Britannica encyclopedia. We get everything there, and volumes. You know how many volumes? They used to have 32 for 36 volumes. So that's a different thing. But basic allegation, if it is not there, then
And then, my lord, washing of a complaint, also here, my lord, 7, 5, 6, 7, 23, 7. Washing of a complaint, FIR should be an exception rather than an ordinary rule. So far as he is concerned. So far as he is. So rarest of rarest.
correct. See, Mr. Goswami, in this case, I mean, in the complaint, there is not an whisper against him about his involvement, correct? About his involvement, nothing is there. Now, in the, I mean, later on, they have brought, I mean, of course, like this person was named as a witness. It is not that he has been brought in new, because in the filing of the complaint only, his name was there. That fact is correct. But then he said, like, I have seen this person with this. Not, at the other end, then nothing, no allegation. Or he has helped something. Like, is there any allegation of that? Like, okay, he has helped her eloping, his word eloping, and is there anything? Nothing. No allegation.
That will come out only during time. It can
But-
come out only during.
But foundation of the case, something should be there. Some iota of something
Now,
is
my
will
lord,
be
the
there.
complaint, my lord, may not be by itself, but complaint will be considered by the court below together with the initial deposition and the evidences. Your lordship will kindly.
Evidence is not there, initial deposition.
There is
And this is a nation statement. Just we have not. Maybe my lord, if he has a good case, maybe get discharged also.
For West facts.
And my lord, the provision of the CRPC, my lord, but the last scene together. This is provided for in the law itself. Now the section will be different. In the evidence, no? Well, I need that. The last scene together.
So when are you going to give me these cases?
These cases were right now.
Okay, please hand it over. Then, like, we will conclude it.
Yes,
Or-
sir.
or-
Yes, sir.
Or you have anything to say?
No, Your Worship.
We'll conclude it and this thing. Will judgment reserve. Please take down. Heard Mr. N.N. Jha, the learned counsel, appearing for the petitioner. Also heard Mr. B.D. Goswami, the learned counsel, appearing for respondent number 2 and S.H. Bora. You have anything to say?
Exceptions. Some of this case has to be made out. That's a complaint.
No, complaint against whom? Against him. What is the allegation there? No, what is the huh? You're supporting him or supporting him? No, your submission should be.
Fairly submitting, Your Worship.
Huh?
Fairly submitting regarding the case.
Exceptions. Some of this case has to be established in the complaint.
We'll record your this thing also. Okay, Mr. Bra, and hearing concluded, judgment reserved. Please hand over the cases. Huh?
That's all, Your
My
Worship.
lord, my case number is 55.
Who are you?
Sir, I'm respondent in person. Means today my case is listed on number 55.
May I, my lord?
May I, my lord, in this case, my lord, I am appearing for her husband, my lord. I am the petitioner in this case. Item number 55, we have filed a criminal petition against a PRC case pending.
Yes. What happened now?
Here, my lord, we have issued
No,
notice.
no,
was
no, what do you want now?
Notice was issued, my lord. She has already appeared today, so.
So,
can-
Sir, the thing is that I have not received any notice. I've just.
and that,
taken
no, okay, I mean, you came to know, the copy will be served to you.
Yes,
Okay?
yes,
Yeah.
we can
So
serve.
copy will be served to you.
Second thing is that there is a means interim order is given, that is the stay to that case. But the thing is that.
No, that you'll have to argue before the court when the matter comes, okay?
But the thing is, once I have to say it, that my husband is missing from 3 months, more than 3 months.
My lord,
And
there are-
there is, means I have not filed any other cases like this and all, because I'm the petition in person and I have 2 children also. So because of that, sir, if you give the stay in that, so how can I mean, sir, मेरे लिए बहुत बड़ा problem हो
नहीं
जाएगा.
वो अभी thing is that like अभी वो नहीं बोल सकता मैं because like I mean on the next date of listing you come I mean if you want to engage somebody you can engage somebody or you want to personally appear you can do that you can submit and we'll hear it and like we'll see whether stay is